in the matter of petitioner Charles Paul Nerswick versus respondent Lindsay Ann Dineski. Ms. Dineski, please state your name for the record.
Lindsay Dineski.
Please raise your right hand. You solemnly swear to affirm any testimony you provide to the court today will be the truth and nothing but the truth.
You always tell the truth.
Strap in, folks, because what starts as a typical court session quickly morphs into a legal standoff like no other. The moment the hearing begins, the defendant launches a full-scale objection, not just to the charges, but to the entire process itself. She claims she was never properly served, questions the judge's authority, and calls into doubt the legitimacy of the court from the very start. The air shifts. This isn't someone waiting for their lawyer to speak up. She's taking the wheel, swerving far from courtroom convention. The judge stays composed, but it's clear this won't be a quiet or routine hearing. It's not just legal proceedings anymore. It's a full-blown clash of ideologies in real time, and trust me, this is just the opening act.
We had a bench warrant to issue for your arrest back in December 4th, 2003.
There was no proper service on that. I was never given any service on that warrant, so it's invalid.
So the warrant issued because you failed to appear
For a court that I never received any service on.
for the show cause hearing. I do see that proof of service.
I was in another state, so there's no way I received any proof of service, and you guys had my email and my phone number, and nobody ever contacted me, so this needs to be thrown out immediately.
So that's not how the court.
Yes, the law says. The law says if I do not have proper service, it's an invalid warrant.
Now things really start to heat up. The defendant doesn't just dispute the court's authority, she practically tears up the legal playbook. She argues that the warrant was wrongly issued, then pivots to claim the court has no jurisdiction over her at all. The judge attempts to steer things back to center, explaining that the warrant was legally served at her last known address, but she's not having it. She talks over the judge, tosses out phrases like due process and fraudulent service, and challenges every response. It's less a legal hearing and more a battle of wills. Every word sparks another volley. The courtroom isn't just hearing arguments anymore. It's caught in a tug of war with the rule book at stake.
Me at the trial on this matter because I've never been able to present any evidence.
Be quiet.
This is my hearing and I'm allowed to speak at my own hearing.
I have to let you know I'm arraigning you.
You're reading it on an invalid warrant. This needs to be dropped immediately. Is this an Article 1 court or an Article 3 court? Because if this is not an Article 3 court, you have no right to adjudicate anything to do with my liberty interests. And my children are my liberty interests, and they are my offspring, and this man attacked me, so this entire PPO is based on fraud and is void. So that not only can you not arraign me, but you need to overturn the PPO immediately.
So, Ms. Dineski, you were served on October 23rd, 2023. There was a show cause hearing for a violation of the PPO that occurred on December 4th, 2023. Just for the record, I have muted Ms. Dineski because she refused to be quiet.
You're not allowed to mute me at my hearing. Is this an Article 3 court or an Article 1 court, ma'am? You have to answer me. Are you an Article 1 judge? Because if you are, President Trump said that you are not allowed to hear anything to do with my liberty interests in his executive order that he recently put out.
All right.
Are you Article?
Is that you stopped Mr. Nerswick's mail? You were interfering with his mail, Ms. Nerswick, and wasn't able to receive his mail.
If you do not have a constitutional oath, then you have to recuse yourself immediately and let me have an Article 3 judge, because this has to do with my constitutional rights. And Article 1 judges.
So the court is in receipt of a customer information form that appears.
You do not consent to this PPO, and you must prove and show your oath.
USPS. At an address of 18337 Ewell Road, Belleville, Michigan.
I was not living there. I had been evicted from there previously in June. So there was no proper service.
the petitioner filed a motion complaining that you, Ms. Dineski, stopped his mail.
I didn't stop anybody's mail. He came and stole my mail and signed for a certified letter that he sent me, so I didn't receive it. And you guys won't let me show evidence. This has been going on for over a year, and I've never once been able to show evidence, and I've demanded a trial multiple times, and you've denied me a trial. So you're going to be going to prison under USC 18, 241 and 242, and I'm going to be asking for the death penalty for you.
Hold on tight, because now we're veering into uncharted territory. The defendant goes on a verbal offensive, quoting criminal laws, accusing the court of overstepping its bounds, and even hinting at federal crimes being committed. She claims the legal system has misled her and suggests that her mail may have been tampered with. Throwing out references to Article 2 and invoking the Constitution, she insists she's governed by federal principles, not state law. Her delivery is fierce, confident, and unshaken, but what she's saying sounds more like the script of a sovereign citizen than any recognized legal defense. It's courtroom drama with high stakes and higher tension, where every declaration feels like a grenade tossed into the system.
Also a bill of payment and penalties, which has been outlawed by the Constitution, Article 1, Section 9, Clause 3. You are using an unlawful PPO to withhold me from my offspring, which qualifies as kidnapping and hostage taking and treason and torture. This matter is void ab initio from the beginning because it's based on fraud, and fraud vitiates everything. Marbury versus Madison, anything repugnant to the Constitution is void. This is a violation of my free speech. This is a violation of my right to petition the government for redress of grievances. It's a violation of my Second Amendment because you said I couldn't have a weapon or bear arms.
Ms. Danelski, I'm going to put you in the breakout room with Ms.
This is a violation of my Fifth Amendment. This is a violation of my Sixth Amendment. This is a violation of my Seventh Amendment. This is a violation of my Eighth Amendment right, my inalienable Eighth Amendment right. This is a violation of my Ninth and Tenth Amendment rights. You are violating all of my rights, and I have not ever been allowed to be heard. Due process allows me the right to be heard, and this has been ongoing since 2023, and I have never had the right to be heard. And I've had my babies unlawfully held from me based on fraud, which I never got to present evidence to prove otherwise.
Then comes the moment things take a surreal twist. The judge steps out momentarily, and the defendant seizes the spotlight. What follows is less a legal defense and more a passionate declaration. A fiery mix of protest, personal ideology, and constitutional citations. She speaks nonstop, painting a picture of a justice system in collapse and a personal crusade for liberty. With no one to interrupt her, she transforms the courtroom into her stage. It's intense, unfiltered, and oddly theatrical, like a TED Talk dropped into a courtroom drama. The law takes a back seat while ideology commands the mic.
We don't have a prosecutor. I'm putting this over. I want to reconvene at 2:00.
I'm demanding a quo warranto.
All right.
And
Deputy, did you hear me? Officer?
Your Honor, I do have a 2:00. Did you want me to come back? I have a 2:00 in judgment.
I don't need an attorney. I don't consent to an
Yeah,
attorney.
I can't. I don't have a prosecutor. I need you to come back. What about 2:30?
I want to say something. You guys are.
Miss Williams,
Your Honor, I'm talking to
5 days.
I have no prosecutor.
I was not even notified of this court. I was not even given notice of this court date, and I've been here.
So let's say 1:45. I don't have a prosecutor.
You need to be quiet. This is my hearing.
Can we do 1:45, officer?
Yeah, 1:45.
Okay,
All right, we'll see y'all back at 1:45.
Okay, thank you, Your Honor.
I do have one question.
Go ahead, officer.
Just for staffing purposes, can you give a time, because that's right around shift change, do you think that hearing would be done by 2:30, or are
I'm
we
waiting on
looking
the
at
prosecutor. I can't
Well, it has
The
to go,
record is
Your Honor, I
going
have
now.
a 2 o'clock.
I can't call it. So,
Prosecutor, I'm asking for this to be
Okay.
dropped.
yeah, 1:45 is the time that I have.
Why
Okay.
won't you
Thank
answer
you,
any
Your
of my
Honor.
questions?
Your Honor, I'll see you at 1:45. Thank
Sounds
you.
good.
The judge returns, but any hope of returning to order quickly dissolves. The defendant, Linde, won't let up. She labels the court a sham, insists she's never received any documents, and cuts off every attempt at procedure. When the judge tries to move forward, Linde barrels through with claims that the case needs to be shifted to federal jurisdiction. She demands subpoenas and refuses to acknowledge any part of the court's process. Even the prosecutor can't get a word in edgewise. She shuts him down without hesitation. This isn't a dialogue, it's a collision between personal narrative and legal protocol, and Linde is steering full throttle.
I do believe arraignments can take place without the prosecutor's office, but
I kind of thought so. I
Must be-
did start, but for this particular one,
Yeah, this one, I think.
considering the fact that,
yeah,
I've been, we needed you here. That's why I started off and I was like, oh no,
Leslie, as far as the allegations go, I do believe that this is a bench-borne arraignment.
hold on.
Oh.
Yep, it is. Let me start to call the case. All right, CJC, are you there? I want to call the case, but I want to hear from you.
Yes.
All right. All right. Thank you. Let me call the case.
Recording in
This is
progress.
case number 23-104850-PP in the matter of Charles Nurswick versus Lindsay Ann Dineski. Mr. Tudge, if I could get your appearance from the prosecutor's office.
Good afternoon, Your Honor. Gregory Tudge, B85961 for the people.
All right. Miss Fort Williams, your appearance, please.
Good afternoon, Your Honor. Gail Fort Williams, P35963, counsel on behalf of Mr.
All right. Miss Fort Williams, you had an opportunity to speak with Miss Dineski in the breakout room.
Why is there still an attorney on my case when I said I don't want one?
I attempted to speak with her, Your Honor.
I do not want or need an attorney.
All right. Miss Fort Williams, I just want you to stand by at this time, if you can do that.
And I'm entitled to relief from judgment under Michigan Court Rule 2.612 because I was not personally notified of this matter. And so it needs to be dismissed immediately.
Ms. Dineski, you were arrested for a warranted issue because of your failure to appear.
A failure to appear on something I was not personally notified on. So under Court Rule 2.6123, not personally notified, I am entitled to relief from this proceeding and action.
And let me hear from Mr. Tudge. Go ahead, Mr. Tudge.
Your Honor, it does appear that 2.512, I believe, was the citation, which 2.516.
I'm sorry, 2.612.
Chapter 2 of the Michigan Court Rules governs the civil procedures. This being a quasi-criminal matter,
This is a civil procedure because it's family court.
Hold on, Miss Dineski. Let Mr. Tudge speak.
It's not quasi-criminal, this is civil.
All right.
So that's a twisting. This is a family court matter.
Miss Dineski, please let Mr. Tudge speak first, please. Go ahead, Mr. Tudge.
I thought this was my hearing. I should be the one speaking.
Mr. Tudge is from the prosecutor's office.
He doesn't need to be on this case because it's civil. Prosecution doesn't happen on civil cases.
Now the courtroom reaches critical mass. Linde dramatically produces a stack of documents she claims will blow the case wide open. She insists on reading them out loud, treating each page like gospel truth. But instead of submitting motions through the proper channels, she goes full steam ahead, disregarding courtroom structure entirely. Her arguments blend legal code with conspiracy, mixing personal belief with pseudo-law. The judge gives her room, but the logic is unraveling fast. Tension is thick, attention is tight, and yet no one can quite get a handle on the chaos. This isn't about finding justice anymore. It's about voicing resistance, raw and unfiltered.
Go ahead, Mr. Tudge.
Thank you, Your Honor. The MCR 2.612 does appear to be governing civil proceedings, this matter being a quasi-criminal proceeding does and is controlled by the court rules which address misdemeanor offenses, unless otherwise stated in Chapter 3 under special proceedings. I do believe that the cited rule is inapplicable for
Right.
this proceeding.
You may
Is
proceed.
applicable or, I'm sorry, I didn't hear him. Did he say applicable or inapplicable?
It is applicable, Ms.
Oh, okay.
Okay, go ahead.
Your
Mr.
Honor, I must correct the court. The argument is not applicable, inapplicable.
Oh, he said not applicable.
Why would it be inapplicable?
He
if
said
this
your
is-
court rule. He's saying the court rule your side, his position, and I agree with him. Let me just say that for the record, that the court rule your side, it governs civil procedure. It doesn't govern under quasi criminal matters.
This is not a criminal matter. This is a civil matter.
Which
It's
is
a
why you're in
domestic,
jail.
it's a domestic matter. How is that criminal?
Ms. Dineski.
And in criminal procedure, it's the same thing. These also, the criminal code
Ms.
also.
Dineski, you have to.
Ma'am, the reason why I looked up the.
I'll
civil
give you
code
an
is because
opportunity
it's-
to speak, but I need to hear from Mr. Tudge first.
But it's my hearing. I should be heard first.
No.
This is my hearing. I'm the one who's supposed to be heard, not the prosecutor.
But they're being heard because you're violated a PPO.
I didn't violate anything. I was not notified.
Sorry,
of
the
anything.
allegation that you violated a PPO.
Okay, well then I have a right to say was not
I'm going
notified.
to give you that opportunity, but you have to, the allegation is that you violated a PPO. You have to let the prosecutor's office, the representative of the attorney from the prosecutor's office speak. Go ahead, Mr. Tudge.
Your Honor, I don't believe I have anything further as to the argument as it relates. I would ask that the arraignment for the bench warrant continue, and I would also ask that the court inform the respondent of the standards for which respondent will be held if proceeding pro se, and I believe it would be appropriate to.
I'm proceeding sui juris and persona.
Well, I am going to ask Ms. Fort Williams to operate.
No, I don't want an attorney. I do
And
not
my
consent to an
attorney.
attorney.
Ms. Dineski, I have acknowledged the fact that you are not wanting an attorney.
No, I refuse it. It's not that I don't want one.
I have Ms. Fort Williams to stand by. She's just going to stand by.
Even though I
What else would
appreciate
you like to say, Mr. Tudge?
I believe it may be of benefit for the court to voir dire or Attorney Williams to voir dire respondent as to a right to have counsel and whether respondent knowingly, intelligently, and voluntarily waives the right to counsel.
All right, Ms. Dineski, you understand? Go ahead, Ms. Fort Williams.
Your Honor, I just wanted to say, Ms. Dineski was speaking about being served with the violation, and she's indicating that she was not served. She may have been quoting the incorrect court rule. I don't know. I don't have the court rules in front of me. It doesn't matter, though. Either way, of course, anybody in court has to be served with the appropriate papers. What she is indicating is that she was not served. And I indicated to her, but I don't think she was listening to me because she was talking and I couldn't talk. I indicated to her that this is an arraignment and that she will have the opportunity to address service or lack thereof, if that is the case, when a trial is set or whatever is set.
No, according to versus McVicker, I can challenge us at any time.
Your Honor, Ms. Dineski, you have to be quiet. For purposes of what she was indicating, Your Honor, it is true that everyone has to be served. I don't know about that court rule, and it doesn't matter whether she's quoting all these rules. It doesn't matter. She's indicating she wasn't served. That's all. Thank you.
Thank you. But the thing is that it doesn't matter if this is
Hold
an
on,
arraignment.
Miss. Procedurally, there are things we have to do, Ms.
No,
Dineski.
not if my rights are violated.
And just when you think the curtain might finally fall, the finale hits just as hard. The judge tries to wrap things up, set a schedule, move the case forward. But Linde's not having it. She declares the entire proceeding invalid, accuses the court of systemic fraud, and promises consequences for everyone involved. She refuses to accept any outcome, recognizing no authority but her own. The judge keeps a firm grip on order, calmly issuing directives, but the courtroom now feels split down the middle, between law and ideology, between process and protest. There's no resolution, no mutual understanding, just opposing forces, locked in a legal standoff that leaves the heir charged and the future uncertain.
Procedure does not have my rights.
Mr. Tudge, do you have a response to that?
Your Honor, it's indicated, I believe in the court record, a proof of service has been submitted. If there are further questions as it relates to service, and ultimately it may be, however, I leave this to either respondent, or if respondent wishes for an attorney, respondent's attorney, to address that if there is a request or a motion to have the court issue a summary judgment as to the alleged violation, the burden of proof would be on the respondent to do so.
All right.
It would not be. The burden of proof is on the one who would process the service. I was out of state when this hearing was set up.
I do show that a proof of service was filed for notice of hearing for the show cause that took place on December 4th, 2024 by the attorney that was representing Mr. Nurswick.
So where did he serve it to? Because I wasn't even in the state of Michigan. I was living out of state at the time, and you guys they have my email, and they never even emailed me. They have my phone number, so I wasn't notified by phone, email, or mail. So if they served it to the Elwell house, Chuck is the one who signed it, which is fraud. He has been defrauding the court since the beginning of this.
There is a proof of service in the file that was filed on November 8th, 2023, that a notice of hearing for the show cause on December 4th went out. Have you, Ms. Fort Williams, talked to your client? How would you like to enter a plea on her behalf? What plea?
No, she doesn't need to enter a plea on my behalf. I said I don't want an attorney. Why do you keep going to her? I want to speak for myself.